Hearing in the queue of the application of Officer W80 against Director General Independent Officer for Police Conduct and others.
Mr. Perry.
Thank you, my lord.
Before we start, I should mention that reporting restrictions apply in this case. The court has ordered that no one shall publish or reveal the name or address of the appellant, who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the appellant or of any member of his family in connection with these proceedings.
Thank you very much indeed, my lord. May it please your lordships, as the court knows, I appear for the appellant together with Miss Davidson. The first respondent, the Director General of the Independent Office for Police Conduct, is represented by my learned friends Mr. Owen, Mr. Simpson and Miss Butler. The second respondent, Miss Iflia Demetrio, is represented by my learned friends Miss Kaufman and Miss Murphy. And the third respondent, the Commissioner of Police for the Metropolis, is represented by my learned friends Mr. Beer and Mr. Cohen.
Perry, I think members of the public members of the gallery are having difficulty in hearing.
I'm sorry.
Because the microphones are probably not correctly adjusted.
Can I hope, I think, may I try that? The court, I'd introduce the parties. The court also has the written submissions on behalf of the National Police Chiefs Council, the College of Policing, Inquest and Stopwatch. The interveners material is located in Part 5 of the court's bundles, and the National Police Chiefs Council has also provided the witness statement from Mr. Chesterman, the Chief Constable of the Civil Nuclear Constabulary and National Armed Policing Head. There is also, I hope before the court, an updated...
Sorry, there's still a problem with audibility, I'm afraid.
I'm sorry.
We'll just ask for the mics to be adjusted.
Thank you. Okay, thank you. Thank you very much. Thank you. There is also an updated first respondent supplementary bundle, which includes some additional information on the consultation process in relation to the revised College of Policing Code of Ethics, which is still in draft. It also includes the 2004 conduct regulations, which I will turn to when I open the appeal, the extract from Bennion that was missing in the original bundles, and there is also the Taylor review, which was the review conducted in 2004, reported in 2005, which forms part of the context for the promulgation of the 2008 conduct regulations. But I'll come to that in due course, if I may. But that's just to introduce that additional bundle. May I then introduce the appeal in this way? The issue arising for your lordship's consideration concerns the use of force standard in the police conduct regulations and the test to be applied for self-defense or defense of another in police professional misconduct proceedings. The use of force standard appeared in Schedule 2 in the Police Conduct Regulations 2012. It's now in Schedule 2 of the Police Conduct Regulations 2020, although there's no material difference. And those...
We're going to be referred
yes,
to the documents which were applicable at the relevant time.
Yes, yes.
And where they're not applicable at the relevant time, we'll be told.
Yes, yes, I'll do that, my lord. I'm going to come to deal with these. The regulations, as the court knows, were made under powers vested in the Secretary of State by the primary legislation, which I will also turn to in a moment, the Police Act 1996. Just to explain in ordinary, simple terms, the use of force standard provides that police officers only use force to the extent that it is necessary, proportionate, and reasonable in all the circumstances. And the issue for the court concerns the meaning of that standard, having regard to the context and underlying purpose of the legislative scheme. Just to put the issue in context so that anyone following these proceedings can understand, the issue has arisen for determination in the context of a decision by the first respondent, the Director General of the Independent Office for Police Conduct, that the appellant, W80, a specialist firearms officer of the Metropolitan Police, should face a disciplinary charge in relation to an incident in which he carried out an armed, intelligence-led intervention on a stationary car in North London and discharged his weapon, causing fatal injuries to Mr. Jermaine Baker, one of the occupants of the vehicle. The incident in question took place on the 11th of December 2015, and at the time of the shooting, W80 says that at the time of the shooting, Mr. Baker's hands moved quickly towards his chest, where he was wearing a shoulder bag, and W80 believed that Mr. Baker was reaching for a firearm, and he, W80, feared for his own safety, the safety of his life, and the safety of his colleagues. There was, in fact, no firearm in the bag, although an imitation firearm was found in the rear passenger footwell of the vehicle. So W80 made a mistake of fact. The circumstances in which the IOPC decision was made are to be found in various locations, and I won't take up time by taking your lordships to them, but there is a statement of facts and issues which is in the key documents at tab 7, page 145. There's a short factual chronology, key documents, tab 7A, page 152 to 153 of the electronic bundle, and a procedural chronology, 154 to 158. There are also, as your lordships know and are familiar with, the judgments of the lower courts, the High Court decision, key documents, part 1, tab 26, paragraphs 4 to 12, which were the facts relied on and adopted by the Court of Appeal, key documents 25, pages 253 to 267. May I just bring matters up to date so that your lordships have the full picture? Since the decision of the Court of Appeal, there has been a statutory public inquiry into the death of Mr. Baker. The inquiry was chaired by His Honour Clement Goldstone, King's Counsel, and the inquiry report was published on the 5th of July 2022. It is in part 4D of the documents, that's Supplemental Authorities, tab 193, page 4498 to 4741 of the court's materials.
Mr. Perry, the members of the court are all working off electronic bundles. Maybe that some counsel are working off hard copies, in which case they will need the references to the tabs, but if they're not, then the electronic numbers will suffice.
Thank you very much, my lord. Thank you. The consideration of W80's position can be found between pages 4704 to 4721. And may I just summarise and give the court the specific references. In his factual findings, the inquiry chairman found that W80 honestly believed that he faced a lethal threat and that it was reasonably necessary for him to shoot in order to defend himself. In other words, he acted in self-defense. That's page 4720, paragraph 13.79, and page 4724, paragraph, or it's on page 4724, and I think it's paragraph 1424 if my note's right. In other words, the inquiry chairman found that the killing was lawful, but in reaching this conclusion, the inquiry chairman applied what has been called in these proceedings the criminal law test for self-defense, as that test would apply at an inquest. See pages 4708 to 4712, and in particular paragraphs 13.19 to 13.37. So he used the criminal law test for self-defense and also was operating on the balance of probabilities as the standard of proof, following the decision of this court in Morn and Her Majesty's Coroner for Oxfordshire, which I know the court will be familiar with. If your lordships wish to have a chronology from the inquiry report, and may I just explain that this may be relevant because of what the Court of Appeal had to say at paragraph 50 of their decision, which is page 266 of the electronic bundle, about public scrutiny of the circumstances leading to Mr. Baker's death. The chronology from the inquiry report itself, the court can see at page 4510 of the bundle, and the court will see there that there had been an inquest that had been opened in 2015. The inquiry was announced in February 2020. It sat over 31 days in the summer of 2021, and as I mentioned, the report was published on the 5th of July 2002.
Did the inquiry chairman say anything about the burden of proof?
He did, my lord. He dealt with the balance of probabilities, and the burden was on those who were suggesting that it was unlawful killing. So they had to establish the fact that it was an unlawful killing.
Thank you.
And simply for the court's note, I don't intend to turn to them because the inquiry report has overtaken events, but just so the court has the references, the IOPC report, the first respondents report, which examined the circumstances of the shooting, which was completed in November 2016, is at pages 1014 to 1248. So that's the full report, the final report. And the decision that was the subject of challenge in the lower courts was the decision dated the 1st of May 2018, and that's at page 974 to 979, with page 978 setting out the direction to the appropriate authority, in this case the Commissioner, to institute disciplinary proceedings. The decision that was the subject of challenge was that the appellant had a case to answer for gross misconduct for using excessive force the Commissioner was directed to put the recommendation into effect, and the IOP decision had been reached, that the appellant had a case to answer, had been reached on the basis that the use of force standard in the regulations meant that the civil law test for self-defence was the applicable test, so that any mistake of fact could be relied on only if it was a reasonable one to make in the circumstances. And your Lordships know in the lower proceedings, the Divisional Court, Lord Justice Flo and Sir Kenneth Parker held the IOPC was wrong to find that there was a case to answer on the basis of the civil law test. The Divisional Court found the relevant test was the so-called criminal law test. In other words, he was to be judged on the basis of his genuinely held belief that his life was in danger. And in reaching that conclusion, the Divisional Court placed some reliance, as the Court knows, on the fact that bodies responsible for investigating and adjudicating upon alleged misconduct were required to inform the assessment of conduct by reference to certain statutory guidance from the Home Office and the College of Policing Code of Ethics, which on the Divisional Court's reading provided for the criminal law test. And I know that your Lordships will be familiar with how the High Court reasoned their decision. The Court of Appeal allowed the appeal of the IOPC and held that the relevant test was the wording in the police conduct regulations without, as the Court of Appeal expressed it at paragraph 50, any gloss, without any gloss, and that it was unnecessary to import any test of self-defense. And these proceedings represent the first occasion that the question of the applicable use of force test in police disciplinary proceedings has been considered by the Supreme Court. And it appears that there are three competing possibilities for your Lordship's consideration. The first is whether the applicable use of force test is the criminal law test, that's the genuinely held belief test, as submitted by the appellant, supported by the third respondent, the Commissioner, and the intervening National Police Chiefs Council. Or is it not the criminal law test, but in fact the civil law test, as was applied by the Independent Office for Police Conduct in the appellant's case, and the first respondent submits that this is effectively what the Court of Appeal decided, supported by the second respondent and the intervener's inquest and stopwatch. The third possibility is that the test in the wording of the standard is applicable without any gloss, namely such force as is necessary, proportionate, and reasonable in all the circumstances, which appears, at any rate on our reading, to be the test applied by the Court of Appeal.
That leaves unanswered the question as to what are the circumstances.
Yes, yes. And Lord, may I try to encapsulate how we see the difference between the three tests, and then I'll summarise our submissions, and then I'm going to introduce your Lordships to some of the materials in a little more detail. But if I may just encapsulate the differences between the three tests. and what the competing positions are. In the criminal law, as your lordships know, the necessity to take action in response to an attack is to be judged on the assumption that the facts were as the defender honestly believed them to be. So that's an honest belief, whether the facts were mistaken or otherwise. And then, so far as the degree of force is concerned, this requires an objective assessment. The objective assessment is an evaluation of whether the force used was reasonable in response to the circumstances as the defender believed them to be. So this is the criminal law test. I might also say, as I'll explain when we come to look at some of the materials, it is also the test under Article 2 of the European Convention on Human Rights.
So both the question of the necessity of using force, or lethal force, and the question of the extent of the force used will depend on the subjective appreciation of the defender.
Yes, although the second limb of is proportionate based on those facts, but your lordship is absolutely right. So that's sometimes called there's some academic literature before the court. It's sometimes described as the subjective test, even though there are these controlling mechanisms. I'll come on to deal with them, but the two principal controlling mechanisms are, first of all, was the belief in fact genuinely held, because the more unreasonable a belief, the more likely it's going to be rejected. And second, there's the controlling mechanism is, even on the facts as you believe them to be, was your response reasonable? In the civil law test, the necessity to take action in response to an attack is judged on the facts as the defendant honestly believed them to be, whether or not he was mistaken. But, and this is the crunch, if the defendant makes a mistake of fact, he's only entitled to rely on the fact if the mistake was a reasonable one for him to have made. And the degree of force is assessed objectively on the basis of the facts as they genuinely and reasonably were believed to be. There are two unanswered questions in the civil law which were left open by the House of Lords in the Ashley decision, and this is why trying to pigeonhole into one category or another can sometimes be is something that has to be approached with caution. There are two unanswered questions. First of all, in civil proceedings, can you rely on what you were told by someone else? So if your mistake, for example, was based on intelligence which had been passed on to you, but it was the intelligence that was at fault, can you rely on it? That was left open by the House of Lords in the Ashley case. And the second matter that was left open was whether you should be able to rely on a mistake of fact in circumstances where an attack was not in fact imminent. So there's... Now, I'll take your lordships to those very briefly in due course, but the point that we make about that is that shows how the civil test is accommodating or looking to what I might describe as corporate liability, because ordinarily in civil proceedings against the police there'll be vicarious liability on the part of the chief constable. And those two unanswered questions in the civil law we respectfully submit show the purpose at which the civil law test is directed. The third possibility... Are we concerned with those questions in this case? No, but if your lordships were to say, for example, it's the civil law test, then I suppose it might also, in due course, the question might arise as to what is the content of that test. So that's the only reason I mentioned it. Lord, so far as the third competing position is concerned, the Court of Appeal test, the wording of the standard without any gloss, appears to envisage an overall evaluation of the circumstances without the conventional two-stage analysis, by which I mean, and what's sometimes referred to as the trigger and the response. The two-stage analysis: what's the trigger, what caused you to do as you did, and what's the response? And the Court of Appeal test, if the standard is applied without any gloss, and if there isn't the two-stage analysis, it appears as though stage 1 and stage 2 collapse, and there is no hard-edged decision on the question of whether a mistake was reasonable or unreasonable. There is an overall assessment of whether the force used was necessary, proportionate and reasonable in all the circumstances. So those are the three competing positions. The IOPC, the first respondent, argued that the Court of Appeal in fact adopted the civil law test, and that appears also to be the view of one academic commentator, Assistant Professor Richard Martin, page 347. His article is at 4342, but that particular point is at 4347. And it also appears to be the view of Inquest and Stopwatch. That's page 4918, paragraphs 5 to 7.
Sorry, reference again, please.
Sorry, my lord. The Inquest and Stopwatch reference, page 4918.
4918.
Paragraphs 5 to 7.
Thank you.
What we say is that the Court of Appeal's approach leaves open the possibility that an unreasonable belief might nevertheless result in a reasonable amount of force. And I say that on this basis, that if the quantum of force actually used was reasonable in the circumstances, notwithstanding the mistake, then that would be presumably a reasonable use of force. And the Court of Appeal seemed to suggest that this was all for the tribunal to determine, and that most mistakes would fall into the category of being reasonable, but the Court of Appeal were not willing to exclude the possibility that mistakes might be unreasonable.
So you say that the Court of Appeal approach leaves open the possibility that an unreasonable belief might result in a reasonable use of force?
Yes.
Which would be the criminal standard?
Well, but Lord, it wouldn't necessarily be the criminal standard, because it would be, because it's the quantum of force which actually, suppose, for example, you thought the circumstances were X, but you only applied force that would be applicable to the situation as it actually was. Theoretically, that
the mistake there hasn't made any difference.
It's not operative.
Exactly. So there would still be much to argue over in relation to how the test operates. But the difference between the parties and possibly with the Court of Appeal is to do with the two-stage analysis and the focus on the question of whether the force used breached the standard, and if it did, whether it amounted to gross misconduct. I might also say that, and I'll turn to it in due course, but may I just foreshadow something, that another point from the Court of Appeal judgment, which your Lordships will recall, at the end of the judgment, the Court of Appeal rejected a point that had been made on the appellant's behalf about the fact that all the training materials supported the subjective genuine belief test, and the Court of Appeal said that that was a matter of mitigation, paragraph 53, should it arise. We would respectfully submit that on the basis of the standard, and also taking the Court of Appeal's test on its own terms, it would also be a question of whether gross misconduct is made out, because the training would be one of the circumstances included within all the circumstances that were relevant. So I simply make that point. May I then summarize our submissions? First of all, the meaning of the standards of professional behaviour and the meaning of the relevant standard is a conventional exercise in statutory interpretation, and the words used fall to be construed in the ordinary way in light of the context and underlying purpose of the legislative scheme. We accept that the Home Office guidance and the Code of Ethics cannot alter the content of the standards, but their relevance is twofold. First, they form an important part of the statutory context in which the conduct regulations sit and shed light on their purpose. And second, as Mr. Justice Cranston, in one of the cases before the court, AB and the Chief Constable, which is at page 3240, but in particular at pages 3256 to 3258, Mr. Justice Cranston said the standards are deliberately drafted at a high level, and the guidance and code are capable of adding detail to guide those who apply them. So they assist in giving content. We also submit that an important component of the court's consideration is the legislative history, because at the time of the regulations promulgated in 1999, I'll take your Lordships to these in a moment, but just setting out at a general level at the moment. In 1999, the regulations were subjective. It was effectively knowingly was the adverbial phrase. Knowingly uses unreasonable force or excessive force. And that was also the reenacted in the standard in 2004. And the current standard appeared in 2008 with no policy explanation as to why there should be a change from a subjective to some other test, whether it be civil or the general test. So you have the subjective test, and then I'll take your Lordships to it following the Taylor review. But there's nothing to the standards are reformulated, but there's nothing to suggest that the previous standard operated in an unsatisfactory way or undermined public confidence.
The date of the Taylor review was
2005. It was carried out during 2004, my lord, and it reported in January 2005. And I'll take your lordships to some of the relevant material in a moment, but what we submit...
Sorry, Mr. Perry, just before you go, do you have the page references for the 1990 regulations and the 2004 standard?
Yes.
Are you coming to those anyway, or you?
Yes.
Yeah, give us. If you're going to come back to this in detail, that's fine.
Yes, I am going to come back to it, my lord, and I'll just check on my. I'll come back to it in a moment, if I may, because I'm just going to make some general observations about what we say is an important part of the context. One of the points that we make is that it's just come back to me. The 1999 regulations are at page 2391. Lord, I'm sorry, I didn't have.
Thank you.
It's 2391 to 2402. And then the 2008, the ones in the original bundles were the Ministry of Defence, and they're now in the supplementary bundle. And they are, sorry, the 2004 are 52 to 53 at the supplementary bundle. So those are the 1999 and the 2004.
Thank you.
As a general submission, we respectfully submit that the wording of the standard is directed at the use of force in lawful self-defense or in the prevention of crime. And as a matter of logic, self-defense almost invariably involves a plea of crime prevention, usually the prevention of an assault, battery, or damage to property. What is reasonable depends on the situation and setting in which self-defense operates, and the situation and setting in this case is the use of force by police officers who are doing a difficult job and required to place themselves in harm's way in order to keep the peace. This factor has weighed heavily with the Strasbourg court in its analysis of the Article 2 case law. And the Strasbourg court, as I will show to your lordships when we come to look at the materials very briefly, the Strasbourg court has rejected claims that the subjective test would operate so as to give agents of the state some form of impunity. What Strasbourg has emphasized is actually the real tension is whether the belief was genuinely held. That's where most cases are decided. In the context of law enforcement, the Strasbourg court has adopted the subjective test and spoken of the need to avoid imposing an unrealistic burden on law enforcement personnel. And we submit that looking at the legislative history, the 2008 regulations, which came out of the Taylor Review, did no more than reflect what had been the prior position, the subjective test, and it reflected the common law position which is explained in all the training materials contemporaneous with that material. And this explains why the contemporaneous Home Office guidance, to which I'll come to, made reference to the special position in which officers found themselves, and that also explains why there was no change in the training manuals. So our position in relation to the Code of Ethics, which was the focus of much of the argument before the lower court, is that it did no more than reflect the position as it has been historically and as the position had always intended to be. And the value of the genuinely held belief test, so what are the circumstances genuinely believed, is that it brings analytical clarity and simplicity to tribunal proceedings in the same way that in the criminal law it brings analytical clarity and simplicity in the adjudication in the criminal courts, magistrates' courts and Crown courts. And it does have the two significant controlling mechanisms that I've mentioned, the genuineness of belief and the reasonableness of the force used.
Well, there's just as much analytical clarity in a test that requires the belief to be reasonable. But the difference is surely that in the criminal case, people are potentially going to be punished and sent to prison,
well,
which requires the mens rea.
Well, my Lord, I respectfully agree that the way the case law deals with the subjective belief from Morgan through to Gladstone, Williams, through Beckford, they are all mens rea cases, and they are all concerned with whether the ingredients of the offence have in fact made out. So I accept that, and I'm not arguing that disciplinary proceedings are criminal proceedings or that the charge is criminal. The value, perhaps I could just say this. One of the doctrinal references to self-defense, or how self-defense was traditionally viewed, was as a justification, as opposed to a mens rea component. So one of the arguments was, historically, and it remains an academic argument to this day, whether in fact self-defense operates to negative an ingredient of the offence, or whether it operates outside offences as some form of overall justification. So what I'm saying, my Lord, is that in this context, it's operating as it would traditionally do, as some form of justification rather than a mens rea component. And that is why it's not necessary to be sidetracked by the fact that the criminal law treats it as a negativing of mens rea. So if you were to see it in the conventional way that that self-defense used to be viewed as a justification, then and move away from the mens rea component, then we submit that it does have a simplicity of application, and we also submit that this is what was attracted. This is what attracted the Strasbourg court, as we will see. The Strasbourg court has noted it's never found a violation of Article 2 where the belief was genuine. It's only ever found a violation of Article 2 where it has declined to accept that the belief was honest. So I accept that the argument ranged against this approach, and it's one that Professor Gardner adopts, the epistemic competence you put people in uniform, you expect them to be accountable, and accountability and public confidence are better served by a civil law test. Our submission is that this, first of all, overlooks the history, and an alternative view, which we invite the court to adopt, is that the police are in fact required to carry out inherently dangerous jobs in order to preserve the peace and uphold the law. And balancing the competing interests, it should be recognised that bona fide errors made by officers in the performance of their purported performance of their duties, as well as their correct actions, are excusable. And the honest versus the reasonable mistake context would be consistent with not only Article 2, but also with the common law. So that's the, in broad terms, the framework of our submission. So I've tried to summarise what the submissions are. May I then?
There's a question coming from Lord Burrows.
I'm sorry.
Screen.
Yes, I'm sorry, my lord.
Could I just ask a couple of questions? The first is, I think you mentioned Professor Gardner then. Did you mean Professor Gardner, or were you referring to the Professor Martin?
No, there's another article, my lord, from John Gardner, and it's in the. I can give you it's also footnoted in Richard Martin's. And it's
4154.
Thank you very much. 4154, and it's the Criminals in Uniform article, the Constitution of Criminal Law. And may I just summarise it, my lord, just so that your lordship knows. Professor Gardner was a critic of the subjective test generally, as many of the commentators are. And he criticises the law of honest mistake generally, and particularly in the case of police officers, but your lordships have that.
Yes, thank you. The other question was, if one were to apply the approach that you're suggesting, what does then one say about the burden and standard of proof? Why logically doesn't it follow through that it should be the criminal burden and standard?
Well, the first answer, my lord, is that the standard in the regulations is the balance of probabilities, and also the rules of evidence don't apply. One of the distinctions that we say between the Court of Appeal decision and our position is the Court of Appeal adopted the approach that if our test were adopted, then the misconduct test would be coincidental. It would collapse into the criminal law test. But we submit that that overlooks the burden and standard of proof, and also the fact that the rules of evidence don't apply.
You referred to the standard of proof by virtue of the regulations. What about the burden of proof?
That's also settled, my lord, as the balance of that it's on the burden is on those who bring the case to prove it on the balance of probabilities.
And is that a statement in the regulations, or is that just from general doctrine of law?
Certainly, there's a case law on it, my lord. Certainly, there's a case in the materials. and I'm told it's not in the regulations. Thank you very much. But there is a decision in your Lordship's bundles, and I'll come on to that in a moment, if I may.
Could I just ask then, is the standard dealt with in the regulations?
Yes.
Standard is in the
Yes.
regulations.
Yes. 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 So, my Lord, I hope that has addressed the. I hope I've addressed your Lordship's questions. Thank you very much, my Lord. My Lord, may I then very briefly deal with some of the materials before the court, just to introduce them. I don't intend to take up much time dealing with some of the materials. Dealing first of all with some of the legislative provisions which contain general justifications for the use of force in the law enforcement context. The court has Section 3 of the Criminal Law Act 1967, which is a general prevention of crime justification. That's at page 1335. It's also set out in paragraph 8 of our written case at page 22.
1331.
1335.
5, thank you.
And Section 117 of the Police and Criminal Evidence Act, which is another general provision authorising the use of force by constables. Section 3 is a general provision. Section 117 is force by constables in the exercise of powers. That's 1336. We make 2 points in relation to these provisions. First, they amount to statutory recognition that police officers are likely to be involved in situations of conflict and possibly personal danger. And second, they feature extensively in the training materials for police officers in general and specialist firearms officers in particular. See, for example, the National Training Curriculum, page 4825 to 4826, and also 4829, and also an ACPO manual, an Association of Chief Police Officers manual, at page 4888 and 4889. And the point is that they make reference to these statutory provisions and also address the subjective test. The Police Act, which is the parent statute of the regulations, Section 50 at page 1339 is the general power vested in the Secretary of State to make regulations for police forces, and that extends at Section 50, subsection 2E at 1339 to regulations in relation to the conduct, efficiency and effectiveness of members of police forces and the maintenance of discipline. Section 39A, which is the power of the College of Policing to issue codes of practice for chief officers, is at page 1337. And at 1337, that is the provision 39A as it was amended by the Anti-Social Behaviour, Crime and Police Act 2014. The point of that is that the College of Policing came into existence in 2012, and then it was through the 2014 Antisocial Behaviour, Crime and Police Act 2014 that the College of Policing gets inserted into 39A. It was originally the power to issue codes was vested in the Secretary of State. So those are the statutory provisions that enable the various codes and regulations to be issued.
Is it relevant that in 39A the power to issue codes of practice relates to the discharge of functions by chief officers of police?
It is, Lord, in one sense, in that it's sort of directing the code to chief officers, but as the route into the guidance is through the Home Office guidance. It's an indirect route because chief officers are required to have regard to the Home Office guidance, and the Home Office guidance also makes reference to the College of Policing Code of Ethics. But your Lordship is right. There isn't a general power for the College to issue guidance in relation to police officers generally.
Thank you.
And then...
just before moving on, the discharge of their functions by chief officers of police, would part of those functions be to determine whether disciplinary proceedings should be brought?
Yes, yes, yes.
So they're obliged to, in discharging that function, to have regard to the code?
Yes, yes.
So there are two ways in it, is it?
Yes, yes. And then, my Lord, so far as the conduct regulations are concerned, I mentioned the 1999 regulations, and if I may just, I know your Lordships looked at them, but it's page 2391 in particular at 2394 is where the relevant use of force and abuse of authority standard was. So this is, you have the 1996 Police Act, and then these are the regulations that were originally promulgated in 1999, and your Lordships will see officers must never knowingly use more force than is reasonable, nor should they abuse their authority. So there's the knowingly, and then that's the same language that appeared in the 2004 version.
But this seems a little bit different from the standard that you're saying applies now, isn't it?
Yes.
Because it's never knowingly use more force than is reasonable. So that would seem that they're made the judge of what is reasonable as well, because they have to know that they're doing something unreasonable.
Yes, yes.
On any view, the standard is different now from...
On any view...
The question is how what is it now?
Yes.
I mean,
yes.
So,
yes. I think what we would say, my Lord, is that this is... There are so many things that fall to be considered in this case before you get to the ultimate question of what it is we're looking at. But what I would say in relation to that, my Lord, is that first of all, it's incorporating a subjective element into the standard, the knowingly, whether or not it was also intended or operated in such a way that Lim 2, if I can call it Lim 2, the reasonable use of force, was also controlled by knowingly. It may be a matter of construction, but the point that we make is that there was, from 1999 onwards, and reenacted in 2004, which is the page 52 to 53 of the supplementary bundle, which contains the code of conduct as it was in 2004, and again there's the use of force and abuse of authority linked together, and officers must never knowingly use more force than is reasonable, nor should they abuse their authority.
The date of this is?
That's the 2004 one, my lord. I think that's apparent from the index.
Yes, and your point is knowingly is there as well. Yes.
It's just the same wording.
Yes.
Yes. So it's consistent with the position, and then
My understanding is that you submit that, and dropping the word knowingly wasn't as a result of anything specifically that was decided. Was including the word knowingly a result of anything specifically decided?
I can't rely on any materials, my lord, to explain
Why knowingly was put in?
why knowingly was put in. What I can say, my lord, is that in the Code for Northern Ireland, which also dates back to, I think the one of the codes was 2003 for Northern Ireland, had relying on the Strasbourg case law, seemed to rely on the subjective test. I'll come to that in a moment, if I may. But one of the twists in this case is, whichever way you look at the materials, it appears as though there's going to be some inconsistency between the various jurisdictions, because Assistant Professor Richard Martin accepts that it's a subjective test in Northern Ireland. I don't think my learned friends necessarily accept that, but certainly it looks as though it's a subjective test based on the honestly held belief. But in Scotland has never had a reasonable mistake doctrine in criminal law, and that's reflected in the training materials in this case also. As to how knowingly came to be included, my lord, and the point about the Northern Ireland regulations is they make express reference to one of the cases before the Strasbourg court, one of the lawful force cases, the Andronicu case, which is that's one of the cases that the Strasbourg court also relied on in the De Silva case as for the subjective test. So it looks as though certainly in the first decade or until 2008, Northern Ireland and England and Wales were proceeding on the basis of a subjective test. Then the 2008 regulation.
Sorry to interrupt you. Can I just be clear as to your response to my Lord Sales's question? I think it was put to you that the 1999 regulations and the use of the word knowingly cannot be said to be consistent with, or perhaps I'll put it another way, isn't the same necessarily as the criminal law test. Is your response to that, as I understood you accepted that? Is it that nevertheless it's closer to the criminal law test?
My lord, it's a subjective test, and I think the point that may have been put to me was whether it goes further than the criminal law test as to whether it's actually knowingly in relation to Lim 1 and Lim 2. But, my lord, I do submit that is that is a subjective component which made clear that the officer, the officer's own state of mind and what he knew was one of the controlling factors in whether you breach the code.
I mean, just as a matter of language, as it seems to me, the knowingly relates to using more force than is reasonable. So that seems to qualify whether there is an appreciation of reasonableness in the use of force.
Yes.
So if anything, the focus is on what you've been calling Lim 2. I'm not suggesting it wouldn't cover Lim 1 as well, but it does seem to, the knowingly word there seems to be directed to Lim 2 as well. And you're nodding. I just want to check that I've understood it correctly.
I think your lordship is right as a matter of language. What I'd say in relation to that, Lord, is that that would seem to be that would seem to be that would also have an impact on what I'm calling Lim 1 as well. Although your lordship is right on the linguistic point.
But one thing we could be sure about is that a deliberate decision was taken to remove the word knowingly. Where
Yes.
that leaves us, I don't think it. At the moment, it goes one way or another on the present question. But clearly, a different test has been thought appropriate.
Well, but Lord, I'll come on to explain what appears to have motivated the change. First of all, for the 2008 regulations, it's page 1755 for the use of force standard. So it's page 1755, which is the current use of force standard. And the background in the change of wording, sorry, it's 1755D, it should be. Police officers only use force to the extent that it's necessary, proportionate and reasonable in all the circumstances. The background to the change in wording is summarised by the High Court in paragraph 15 of the judgment. That's at page 214. But what appears in paragraph 15 is largely derived from the explanatory memorandum to the regulations, which is page 4376 to 4380. And your lordships also have in the supplementary bundle the Taylor review. And if I may just give your lordships, if I may just go to the Taylor review, it's included in the supplementary bundle at page 61. That's which is the front page, which gives the date. It runs through to page 109.
The supplementary bundle 61.
Yes. And there's an executive summary at page 63. I'm not going to go through it in detail, my lords. I'm just going to identify where your lordships might find might have the most assistance from these materials. But there's an executive summary, and the point that we'd just invite your lordships to note is that there's nothing in relation to the use of force standard. We'll see what the Taylor review had to say in a moment, but it's more to do with trying to make a less bureaucratic and legalistic system for dealing with complaints. And then at 65, there are 6 recommendations which had the support of the programme board, which was the stakeholders who had been involved, and that your lordships will see that a new single code incorporating ethics and conduct should be produced to be a touchstone for individual behaviour and a clear indication of organisational and peer expectations, and a model appeared at H, and the model at H is at page 138 of the bundle. And the lordships will see at 139 there's Article 4, which is the abuse and use of force. Police officers must never abuse their authority. They may use force only when necessary and to the extent it's reasonable and necessary to obtain a legitimate objective. Police officers must respect everyone's right to life and must not under any circumstances inflict, instigate or tolerate any act of torture, inhuman or degrading punishment. So that's what was included in the annex. And then when it came to discussing that recommendation, may I just take the court back to page 74?
Sorry, just before we move on from that, I'm going back to what Lord Leggett was saying. I mean, it does look as though there has been a deliberate decision to drop the word knowingly and to cast things in terms of what might be thought to be objective standards, only where necessary, only to the extent it is reasonable and necessary to obtain a legitimate objective.
Well, my Lord, may I then go to the point because your lordship sees the rationale at page 74.
Yes, certainly.
Because this is what the Taylor Review had to say about it, and for a code to be embraced, it needs to be simple, realistic, readily understood by the organisation and the individual. If it's too esoteric or value-laden without a firm base in reality, it's likely to be seen as desirable and not essential. And then it says, the code produced in Northern Ireland is said to be working well to date.
Sorry, you're reading paragraph
4.2.1, I'm sorry.
Sorry, 4.2.1. Thank you.
I'm sorry, but page 74.
My fault. Thank you very much.
And the code produced in Northern Ireland is said to be working well to date and based on the Council of Europe Code. There was no disagreement about the board that a single code was the preferred position. The wording of the proposition at Appendix H took as the starting point the present Code of Conduct and incorporated into it all the values contained in the Council of Europe Code of Ethics, which the EU is currently looking to adopt. It takes account of comments from the programme board and represents a version that could now be considered in greater detail and shared with a wider family of practitioners. So your lordships are absolutely right that the knowingly has disappeared and the code is markedly different, but there is a mixed, perhaps a mixed message here, because the Taylor Review acknowledged the code in Northern Ireland appears to be working well to date, which was based on the Council of Europe Code, and that is the in Northern Ireland, we respectfully submit there's a subjective component.
Where do we find that?
The position in relation to Northern Ireland, my Lord, is 2540. Perhaps I could just sort of...
Mr. Perry, sorry to bombard you with requests for references. There's reference here to the Council of Europe Code. It would be useful to have that as well.
Yes. My Lord, may I just deal with the...
Of course, sorry.
No, not at all, my Lord. I think the Northern Ireland Code of Ethics is 2540, and I'll just sort of, if I may just, which is the and if I may just sort of pick it up at 2535, because your lordships will see that these are in fact the 2016
2535.
2535 it should be, my lord. It should be the Police Conduct Regulations, Northern Ireland. And the difference between the position in England and Wales is that the Code of Ethics is incorporated into the schedule of the Code of Conduct Regulations, along with a standard of behaviour. So your lordships can see at 2540, there's the preamble, and then the various aspirational statements, and then the Code of Ethics, and then
so just that I can be clear, this is this the current Northern Ireland position? Yes. So not the code that was being referred to by the Taylor Review, but are they the same?
Yes.
Right.
For these purposes, my lord, they're the same, and I can provide that if necessary, my lord. But your lordships will see that the use of force is at 2543, and it's a different structure in terms of the drafting, because 4.1 is, so far as possible, apply non-violent methods before resorting to force, and then it should be the minimum appropriate in the circumstances, then, and the source, and then 4.2 is planning and control, which is sourced to McCann and the United Kingdom, which was one of the authorities. It's the shooting of suspects in Gibraltar, where there was criticism of the planning and control of the operation, and the United Kingdom was in violation of the Article 2 obligation. Then 4.3 is where it's necessary to resort to the lawful use of force, exercising restraint, etc. And those. And then 4.4 is the important provision, although it is limited to the discharge of a firearm. But I'll explain the significance in a moment. A police officer shall discharge a firearm only where the officer honestly believes it's absolutely necessary to do so in order to save life or prevent serious injury, unless the discharge is for training purposes or the destruction of animals. And then it refers to Andronicou and Constantinou, which was one of the leading cases before the Strasbourg court. But it's anchoring the use of the discharge of a firearm to the honest belief test. So, and the point that we would make is that it would be curious, to say the least, if it was an honest belief test for the discharge of a firearm, but a different test for other uses of force. So,
but that's not the test for the use of force with a firearm, or not the only test, is it? It's an additional criterion that you should never discharge a firearm unless you honestly have an honest belief. But then you've also got to conform with 4.3, for example, to resort to the lawful use of force or firearms.
Well,
so it's not a freestanding sort of sole requirement for a firearm. It's just on top, isn't it, of the use of force test when you're discharging a firearm?
Well, but Lord, save only that there is a reference to the case which the Strasbourg Court has made clear that it's the honestly held belief test that's the controlling test. And if it's the honestly believing test, that's the honest belief test that's the controlling test, our respectful submission is that that's a subjective test, and that's what it was. That's what the position was in the earlier regulations in Northern Ireland, and this is why I would respectfully submit that Assistant Professor Richard Martin accepts that the position in Northern Ireland appears to be a subjective test. And that's, for your Lordship's note, that's page 4366. He appears to accept.
If I remember, the Cyprus case, there was protesters about the division of Cyprus, and it's a sort of case about when you can fire at a crowd if you're under threat as a soldier or a police officer.
It was
a slightly different situation from when you're using force to...
It was actually, my Lord, your Lordship is absolutely right. There's another case of that sort. But
it's a different one, is it?
This is where 2 people were shot on Christmas Eve.
Right.
In an armed operation where the tragic circumstances were that a young woman had been taken hostage by her fiancé, and he threatened to kill her come midnight. And the police decided to mount an armed intervention, and both were killed.
Right.
And the Strasbourg court said it could not put itself in the shoes of the police officers. And it said that it was the honest belief test. And in the De Silva case, which is the latest statement in this area from the Grand Chamber, the Grand Chamber has used the Andronicou case in support of the subjective belief test.
Right.
But your Lordship is absolutely right. There was another case about shooting into crowds, but the case that's sourced by the...
Yeah, no, thank you.
But the position in Northern Ireland is also addressed, for your Lordship's note, by Mr. Chesterman in his witness statement, and that's at page 4788. And where he produces the Code of Ethics. And we accept, my Lord, that the position in Scotland is different. But what we do say is that Scotland does have a different test, and Section 76, for example, of the 2008 Criminal Justice and Immigration Act applies to England and Northern Ireland, but, for example, doesn't apply to Scotland. So you expect the differences and for there to be greater alignment between England and Wales and Northern Ireland. The key point that we would make in relation to the Taylor Review, and I'll just try to summarise what our case is so that your Lordships have it, and then your Lordships know that you've got the review. The key point that we would make is that there's no indication in any of the materials that the standards were to move from a subjective assessment. And there's no indication in the materials that the position was to be decoupled from the position as it was in Northern Ireland.
I mean, I can see that you can say that there isn't a sort of policy discussion of that change, but I mean, there is an indication in that they've deliberately moved away from the word knowingly, which was on the table before them, and seem to have adopted a formulation which does, if you just read it, look as though it's framed in objective language.
I accept that, my lord, and my point is that in the absence of any in the absence of any indication of a policy reason, not only to move from a subjective to an objective assessment, but also to differentiate the position in England and Wales from Northern Ireland, we would submit that the code was intended to reflect the position as it had previously been in relation to any subjective belief. And we also rely on the fact that the training materials and manuals that existed at the time made no give no indication that there had been any such change.
Sorry, when you say the code was intended to reflect what had previously been said, you actually mean the ethics code there? Or did you mean the standard?
The standard. Sorry, my lord. Sorry, the standard, yes.
It's a bit of a paper chase, Mr. Perry, I'm afraid.
But, my lord, there's so much material, and it's unfortunate that it's quite as complicated as it is, but there's been understandably perhaps in a sensitive area such as this, but in particular, my lord, in relation to the training, for example, see the National Police Firearms Training Curriculum. It's page 4742 to 4763, and the subjective element is referenced at 4747. And there is also a discussion of the various training in the public inquiry report, the various...
Before you move on from the National Police Arms Training Manual,
yes,
I mean, that doesn't have a statutory hook to hang on, does it?
No. Or the only point I'm making, my lord, is if you look at the contemporaneous materials, given that all these people were involved in the process of consultation and were parties to what was taking place, it appears as though if there was a change, it was unnoticed by all those who were delivering the training to police officers who talk in terms of the. I mean, I don't want to get too bogged down in that, law, because you also get involved in interpreting the manuals, which is. Sure. Which I don't want to. I accept that, but. What you don't find anywhere is a statement. We've changed the standard, and this is how you're now going to be trained. Which is why I said at the outset, the tailpiece to the Court of Appeal decision about the that goes to mitigation is perhaps worthy of more consideration than the Court of Appeal was willing to give it.
Mr. Perry, I mean, I take your point about we don't want to get drawn too deeply into the manuals, but I mean, looking at page 4747, that is looking very much at the criminal defence in the strict sense, and presumably the manuals have to cover, or potentially cover, a range of things, because police constables maybe probably do need to know what the limits on their activities imposed by the criminal law are, so it's relevant to them to know that. it isn't necessarily the case that the fact that the criminal law is talked about, that must be taken to be an indication that that's the only standard that can possibly apply.
I acknowledge that, Lord, and the point I'm making, Lord, and it's the point that Mr. Chesterman makes, I suppose, is no one appears to have noticed this change and query whether it was intended in context that there was to be any change. Then,
Mr. Parry, just if I may, to back up what Lord Sales just said, if you go to page 4748, you see the exact words of the regulations repeated under the heading of regulations. So it's quite clear that that particular manual was just dealing earlier on with the criminal law of self-defence.
I fully accept, my lord, that the focus is on the criminal law. That's true of the manuals, generally speaking, and there isn't anything that expressly addresses the context in misconduct. But the manuals also, without getting too drawn into what an exercise in construing the manuals, but the manuals also tend to address the common law in a portmanteau way, that in the sense that it's a subjective component to the test. But I fully accept your lordship's point, and before that, my Lord Sales' point about the focus in those manuals. So the point I'm making is a limited one. But I do place it before your lordships for consideration.
I mean, in fact, the manual, I mean, if one looks further up the page, refers to Scottish law separately, and then refers to the Scottish regulations. So the manual seems to be trying to inform police officers of a range of rules that they may be subject to. It doesn't necessarily, in fact, it clearly doesn't follow that they're all the rules are the same. Then they may have to bear a number of things in mind. I mean, insofar as one can.
Yes. Well, my Lord, if we were redrafting all the manuals, we might start afresh.
Sure.
And make it clearer. But given that part of the point of the changes and what's included in the manuals is to express in simple terms what is being conveyed, what the clear message that comes out, at any rate in relation to the common law, is the subjective component. But I accept that there's limited weight in relation to that. The Home Office guidance, which is issued under Section 87, subsection 1, the 2008 guidance is at page 2199, and this is the guidance that was contemporaneous with the 2008 regulations. And just to sort of navigate through this very briefly, there's page 2204 is the introduction, which contains the explanation for what the guidance covers, and B, what power was vested in the Secretary of State to issue it, and C, designed to further the aims of being fair and arriving at a correct assessment. And then there's the glossary at 2205, and then chapter 1 is at 2208, which is the guidance on standards of professional behaviour, which deals with public confidence in the police is crucial, and 1.2, the standards reflect the relevant principles of the Convention and the Council of Europe Code of Ethics, which the Council of Europe Code of Ethics isn't before your Lordships, but we'll make sure it's available. And then there's an explanation of the standards, and the use of force is at 2211, and your Lordships will see at 132, police officers only use force to the extent it's necessary, proportionate and reasonable in the circumstances. There will be occasions when police officers may need to use force in carrying out their duties, and then it is for the police officer to justify, that's the language of justification, his or her use of force. But when assessing whether this was necessary, proportionate and reasonable, all of the circumstances should be taken into account, and especially the situation which the police officer faced at the time. Police officers use force only if other means are or may be ineffective in achieving the intended result. And then 1.35, as far as it's reasonable in the circumstances, there's reference to the law enforcement provision, Section 3 and Section 117, and a reference to the common law, making it clear that force may only be used when it's reasonable in the circumstances, which reflects and is very similar to the training manuals. And then 1.36 is Article 2, where reference is made to a stricter test. It may not actually be entirely accurate to say that there's the stricter test, because when this was being drafted, of course, there was the various cases were going through to the Strasbourg court under Article 2, and the question was, what was the absolute necessity test for the use of lethal force? That's now been clarified, and of course it's only where it is absolutely necessary, but the content of that has been clarified by the Grand Chamber in De Silva. And then 1.37 is the end of that particular section.
And I'm so sorry. The status and purpose of this document is what? You say it's the Home Office guidance. Who is it directed to?
It's directed to police officers, and it's in relation to your Lordship will see at 2204. It's issued under Section 87(1), and it's directed to all police officers. It also includes special constables and those responsible for administering the procedures described in the guidance, and they're reminded to take its provisions fully into account when discharging their functions. Now, Lord, where this fits in is that this was effectively before the College of Policing. So what we come on to in 2014 is the College of Policing Code of Ethics. So instead of having the Home Office providing these guidance on professional standards, the college then steps in 2014, and there's more Home Office guidance, which then makes reference to the college. So the 2014 is at page 2.
Before we leave this, do you say there's any clue in this as to whether the test is subjective or objective?
But Lord, only that it talks about especially the situation which the police officer faced at the time, which it's attaching a special weight to the situation which the police officer faced at the time.
But not to their perception of it. No. I mean, all this reads objectively, doesn't it? What was the situation they were in, and did they act reasonably?
Well, Lord, I make the point about especially the situation which they faced at the time, but I accept that there is nothing in this that provides a basis for an express acknowledgement of the subjective test.
Thank you.
And then the 2000. I'm sorry, Madam.
Did this guidance, did it cease to have any effect after the 2014 guidance came?
It's replaced by the Lord, yes, and it's replaced by the 2014, and in fact we can see the 2014 at 2217, and this, at 2223, this is the 2014 guidance. We can see at 2223 at the top, there's the introduction, and then there's reference to the guidance issued by the Secretary of State in B. And then, in relation to 2227, there is now reference to the College of Policing. So, from 2008, there was other Home Office guidance in 2012, but that was materially identical to the 2008 regulations. But since those earlier regulations, the College of Policing has been established, and your Lordships will see, paragraph 1.1, the professional body for policing is responsible for setting standards of policing practice, etc. The Code of Ethics sets out in detail the principles and expected behaviour, and 1.2, the Code is a statement of expectations, and 1.3, what the standards do, and 1.4 was the subject of much discussion in the lower courts about the Code of Ethics should inform any assessment or judgment of conduct when deciding if formal action is to be taken under the conduct regulations. So that was the route into the Code of Ethics, and then 1.5 is a breach of the Code. Will not always involve misconduct or require formal action. And then at 2228, there's then the standards, and instead of what we saw previously in 2008, your Lordships will see at 1.17, police officers only use force to the extent that it's necessary or proportionate. Necessary, proportionate, and reasonable in all the circumstances. And the
1.17, yeah.
1.17, yes. And then the Code of Ethics to which reference is made is at page 2234. So that's where the code is. So in 2014, you've got the Home Office guidance making reference to the Code of Ethics, and then the Code of Ethics is at 2234, and there's the foreword at 2237, then an introduction at 2238, and then a preamble, and then the standards of professional behaviour begin at, the discussion begins at 2242, and then your Lordships will see that the standards, the 10 standards, are there set out with the use of force at 4. I will only use force as part of my role and responsibilities and to the extent it's necessary, proportionate and reasonable in all the circumstances. And then that leads on to 2246, where there is a repetition of what's contained in the box, and then an explanation at 4.1 to 4.4. And at 4.4, you will have to account for any use of force. In other words, justify it based upon your honestly held belief at the time that you used the force. So that we would submit there are 2 points. First of all, the language of justification, and second, the reference to honestly held belief. So far as the Court of Appeal decision is concerned, the Court of Appeal said that this was doing no more than requiring the police officer to explain and give an account of why he used force. We respectfully submit that it goes beyond that, because the language of honestly held belief is a reference to the conventional test in Strasbourg and in domestic criminal law proceedings, and also justified is beyond, we would respectfully submit, goes beyond explanation. It is not our case, just to be clear, it is not our case that the code does anything as ambitious as altering the standards. Our case is that the code is merely continuing what had always been the case, to reflect the subjective criminal law test as it had been prior to 2008 and as it had been since 2008. And the reliance by the Court of Appeal on the authorised police practice post-incident procedures, that's at page that's at paragraph 46 of the Court of Appeal decision, but the document to which the Court of Appeal made reference does itself contain a reference to honestly held belief. See page 2373. And the document also refers to common law principles with the subjective test. That's 2356 to 2357.
Sorry, 2356. What do we find there reference to?
It's reference to the common law principles and the subjective test. I accept it's in relation to the criminal proceedings, but it's the reference to the honestly held belief.
And again, does the authorised police practice have a hook on which it hangs within the legislative structure?
No. These are all non-statutory.
I'm so sorry. And so the document at 2356 is what exactly?
That's the it's the authorised. Sorry, my lord. May I just get my?
It's referred to as the APP, I think.
Yes, it's. Have I got that right? It's the correct title is the authorised professional practice. Sorry, authorised professional practice armed policing, and that's. It includes in the bundle the legal framework, the common law at 2356, and providing an account at 2373. There is also, for your lordship's note, There is also some discussion of the training materials and the authorised professional practice in armed policing, which gives a summary overview in the public inquiry report at page 4519 to 4521. And what it does, what the inquiry chairman did, was to explain what the authorised professional practice armed policing was, and also he explained the National Police Firearms Training Curriculum. So that's at 4519 and 4520. So your lordship will have an indication of what those documents are and how they fit into the overall scheme, certainly in relation to training. And then I'm going to adopt what we say in our written submissions in relation to the code. I also don't need to address your lordships on what we say in our written case in relation to disciplinary proceedings. It's at pages 27 to 29 of the electronic bundle, where we summarise police disciplinary proceedings. I can summarise the position in two propositions. First of all, we accept that disciplinary proceedings are neither criminal nor are they civil proceedings. They are, as the High Court and Court of Appeal expressed it, of their own type. And we also accept that disciplinary proceedings do not involve the determination of a criminal charge for the purposes of the European Convention on Human Rights. There's long-standing authority to that effect. See, for example, A in the United Kingdom, page 3399, and Lee in the United Kingdom, 3488.
3488.
3488. And then we've also addressed in some detail in our printed case the law of self-defence, which I know your lordships will be very familiar with, and the various authorities. The only points that we would seek to make by way of oral submissions are fourfold. First of all, the criminal law, which applies the subjective test, makes clear that the abandonment of the objective standard did not lead to successful spurious claims of self-defence. See Lord Griffiths in Beckford, page 1899. 2.
Sorry, bear with me a moment. The abandonment of the objective
standard did not lead to successful spurious claims of self-defence. See the Lord Griffiths in Beckford, page 1899. Second, the reasonableness or unreasonableness of the belief is mere material to the question of whether it was held at all. And again, as Lord Griffiths noted in the Beckford decision, where there are no reasonable grounds to hold a belief, it will only be in exceptional cases that it will be concluded that it was held. The third point we make, Lord, is that the law of self-defence, applying the criminal standard, is not complicated. There are plenty of statements of principle in the authorities that it represents a universally recognised concept, easy to understand and easy to apply, particularly by lay tribunals in the criminal sphere. And 4, the criminal cases recognise that where in a moment of unexpected anguish a person does only what he honestly and instinctively thought was necessary, that will be potent evidence in support of both limb 1 and limb 2 of the defence. And just before the short adjournment, Lord, may I just give your lordships the references to the 2 points in Ashley to which I made reference when foreshadowing our submissions about the solution 3 in the civil law, whether you must in fact establish there was an imminent and real risk of attack. Ashley is at page 1957, and on the possibility that solution 3, as the Court of Appeal described it, the imminence and real risk of attack might in fact be the correct solution. See Lord Scott, page 1970, paragraph 20, and Lord Roger...
Sorry, paragraph?
Paragraph 20. Lord Roger, page 1979, paragraph 55, and also the second point, the House of Lords leaving open whether you can rely on inaccurate intelligence, for example. Also, paragraph 20 for Lord Scott. And Lord Roger, paragraph 54, page 1979, and Lord Newburger, page 1989, paragraphs 93 to 94. 93 to 94.
At the end of the day, we just have to construe one sentence, don't we? And there's nothing in that sentence that gives any hint that we're to focus on what the police officer may subjectively but mistakenly to have believed. All we get from it is the standard of reasonableness. And in the absence of anything else, why doesn't that govern the whole of his behaviour, including what he believed?
Well, my Lord, what we say is that looking at the standard and giving it content, rather in the same way that reasonableness in the context of criminal proceedings has been given a particular content, that's the position here, and it would reflect what was historically the position, and also the position in Northern Ireland, if we're right about that, and also the position in Strasbourg. So, Lord, we say that these are all contextual matters that inform the legislative purpose. So that's the case that we make, my Lord. And, Lord, I've got very little...
I can't see how one calls an aid what happens in Northern Ireland, because Scotland has a different system and so on. So why not just concentrate on the actual statutory language used?
Well, I suppose, my Lord, the point that we make is that there's a point of symmetry in relation to two jurisdictions which do share a common law defence that's based on the honestly held belief point. And also, it's because the Northern Ireland Standard expressly draws on the Article 2 jurisprudence, then that informs the standard with which we're concerned. But Lord, after the
before you move on, can I just ask this? Did I understand you to say earlier that in Scottish criminal law, the concept of the unreasonable, honestly held mistake is not accepted, and so the Beckford line of authority doesn't apply to Scotland?
Yes, that's...
There's no equivalent of the Beckford line?
There's no equivalent, my Lord, and that's been apparent since the leading case, I think, was in the 1950s, and attempts to modify the position have been unsuccessful in the High Court.
Thank you. Thank you, Mr. Perry. We'll rise now. We'll sit again at 2 o'clock.
Thank you very much.
Thank you very much.